What will happen if auditor discovers any irregularity, such as fraud or falsified account but not disclose it? Will auditor be sentenced to any court judgment? Have this kind of question ever crossed your mind? Well, you might be wondering how the real case looked like. My name is Nushahira binti Muhammad Isa and I am final year accounting student from UNISA. In this video, me and my friend will share to you 2 real cases that we have been studied. And let's get started.
Assalammualaikum warahmatullahi wabarakatuh. My name is Aidit Nasir. So we're going to jump straight to the first case, which is Stone & Roll Limited versus Morse Stephen. The case occurred in 2009. Let's jump straight to the case fact. First, Stone Roll Limited are a wholly owned company directed by Mr. Stojevic. So, what does Mr. Stojevic do? He deceitfully siphoned Stone asset away and falsified the account. Next, first we need to understand about the term ex turpi causa non orito actio mean. It means that a plaintiff will be unable to pursue legal relief and damage if it arises in connection with their own tortious act. Due to that, Morse Stephen requested that the claim to be struck out even before any question. But ignoring the fact, the case are brought into judgment. So let's see about the judgment. The first one is House of Lord. House of Lord judgment split 3 into 2 as to whether a firm auditor, which is Morse Stephen, should be held liable for the negligence due to the fraud committed by Mr. Stojevic regarding a major bank loan. But later, Lord Brown stated that Mr. Stojevic was in control of the company as its sole actor. Next, the case are brought to Court of Appeal. Remand LJ summarized Morse Stephen did not owe a duty of care in this case. But illegality defense could not be removed simply because the very thing the auditor were meant to do was to detect fraud. Later, the case are brought into the High Court. Laili J held Mr. Stojevic's action and state of mind were to be attributed to the company. However, because detecting the fraud was the very thing the auditor were engaged to do, they would not be allowed to rely on the ex turpi causa defense to a negligence claim. So, that's all from the case 1. Let's jump straight into case 2.
Hi, I'm Lana. So we proceed to case 2, Deloitte and Touche versus Livent Incorporate. Livent produce and stage performance in data that is honored in Canada and US. They also have a share listed on the Canadian and US stock exchange. The case was begun when Livent director manipulated the company's financial record to enhance Livent's success. They hired Deloitte as an auditor for the company, but Deloitte never uncovered the frauds. In August 1997, Deloitte found irregularities in the statement of profit, but Deloitte did not resign as an auditor. Instead of that, they helped Livent to prepare and approve press release about the issue. The new equity investor discovered the issue and the subsequent investigation and re-audit about the financial record was begun. Livent filed for insolvency protection. It sold its asset and went into a receivership. And lastly, Livent sued Deloitte in the torts and contracts.
Now, I will proceed to explain regarding the trial and Court of Appeal decisions on Deloitte vs. Livent case. In this case, the judge held that Deloitte owed and breached its duty of care to Livent shareholders' ultimate benefit. They conclude that Deloitte failed to meet the standard of care, first, when it failed to discover and report the irregularities in 1997, second, when it signed off on Livent's 1997 financial statements. Therefore, the judge awarded Livent damages of just under $85 million and dismissed the appeal and cross-appeal. That's all from me, and I will pass to the next presenter.
Hi, my name is Shafika. So now we move to what we can learn from the both case. From the first case, we can learn that how important the clarification of scope of duty owed by the auditor. An auditor needs to be independent and be more efficient in doing their work, especially in detecting the fraud happening in the company. Next, we learn about the ex turpi causa. Ex turpi causa is a doctrine that states a plaintiff cannot claim the loss that they suffer from their own tortious act. From the second case, we can learn that the auditor must take care in discharging their duties. The integrity and professionalism is very important in doing the auditor's opinion.
As they failed to do the auditor's opinion in honest, the auditor result to suffer the significant loss and exposure to the damage. That's all from us. Thank you for watching. Bye-bye.